This has been a landmark decision in Sri Lanka, commonly known as the Sepala Ekanayake case. Actually, the repercussions of this case, or the consequences of this case, could make a sea change in the constitutional law of the country. So let's try to unravel the case bit by bit. The incident happened in 1982. June 29th was the date when a Sri Lankan citizen residing in Italy at the time, called Sepala Ekanayake, hijacked a plane. And the plane was ordered down at Bangkok airport, where he demanded ransom of $300,000 as well as the return of his wife and child from Italy back to Colombo. So that's the gist of the case. So this particular incident was then negotiated by government of Italy as well as the ambassador of Sri Lanka in Bangkok, of course, with the officers of the Sri Lankan government. So they made a deal, cut a deal with Sepala Ekanayake. So he would release the plane, and he was given $300,000, and his child and wife was brought to Colombo, and Sepala Ekanayake was given safe passage to Colombo, Sri Lanka, without being arrested by Bangkok police. And then, through the Katunayake airport, he went free. He stayed in a Colombo hotel for a night or two. Then, en route to Galle, he was arrested. Charge, illegal possession of cash under section 394 of the Penal Code. Now, why is such a charge? Why couldn't we charge against him for the hijack of the plane? Well, by that time in 1982, Sri Lanka did not have any law on hijacking of planes. So the only recourse available for him was take action against him for extortion, maximum 5 years of imprisonment. So the aftermath of the particular incident is what that makes the case very famous, or rather infamous. So by the time, as I discussed earlier, Sri Lanka did not have any law regarding hijacking of planes. But the thing was, in 1963, 70 and 71, Sri Lanka had signed 3 conventions particularly focused on hijacking of planes, because this is a problem, heavy problem in 1960s and 70s in the world. So there were a couple of conventions. One was the Tokyo Convention that you can see, next the Hague Convention, and then the Montreal Convention. But the sad aspect was, although Sri Lanka has signed and ratified them, actually we ratified them in 1978, we haven't passed enabling legislation, that means laws inside the country to activate these conventions. We hadn't passed any law on it until 1982. So by the time Sepala Ekanayake did the hijacking by June 29th to July 1st, there was no law in the land that could punish him. So what happened thereafter? Sri Lanka passed an act called Offences Against the Aircraft Act, and this was done exactly 1 month after the crime had, or rather action, or by Sepala Ekanayake. Can't call it a crime at the time, right? It wasn't a crime. So only 1 month later, Sri Lanka passed a law called Offences Against the Aircraft Act. There we incorporated all the 3 previous conventions, and specifically mentioning that the hijacking of a plane abroad is wrong, crime, resulting in the life imprisonment. And with the use of the new law, we did the next. Took action against Sepala Ekanayake and punished him with a life imprisonment by the High Court. So the particular act, Offences Against the Aircraft Act, specifically stated in section 17. It covers any action on board against an aircraft, as well as any action done by a Sri Lankan in a foreign aircraft. So this new law was sufficient to take action against Sepala Ekanayake. So he was punished, sentenced to long-term imprisonment, life imprisonment. But the thing was, this law that came after he committed the wrong was not one that Sri Lanka constitution would allow. Our section 13.6, or we call it article 13.6, clearly says, take a look, that we cannot take any legal enactment against a person for doing something that was not a wrong when he was doing it. So we cannot pass a law thereafter and make what he did in the past wrong and punish him under the new law. So we call it ex post facto legislation, or we can call it retroactive legislation. Sri Lankan constitution specifically forbade it. So this was the argument filed by both Kolinada Silva as well as Rambanda Seniviratna, Sri Lanka's most eminent criminal lawyers. They petitioned on behalf of Sepala Ekanayake to the Supreme Court, stating that this particular new act that we passed after Sepala Ekanayake has done the act of hijacking, right? We passed this new law after that with the purpose of punishing him for what he did before that, right? So they petitioned the Supreme Court, telling that it's a specific violation of the Article 13 of the Constitution of Sri Lanka. So Supreme Court had to get the petition on. But however, Supreme Court was not that much interested in this earlier part, which was this, that the lawyers, the eminent legal professionals are harping on, that no person shall be held guilty of an offence on account of any act or omission which did not at the time of such act or omission constitute such an offence, and no penalty shall be imposed for any offence more severe than the penalty enforced at the time of such offence was committed. Well, Supreme Court ignored it technically. They went after the second paragraph of the same article, Article 13.6. It says something pretty interesting. Take a look. Nothing in this article shall prejudice the trial and punishment of any person for any act or omission which at the time when it was committed was criminal according to the general principle law recognized by the community of nations. So what does it infer? It in simple language means even if a wrong done by a Sri Lankan is not clearly stated in our criminal law as a crime, but at the time he was committing that, if that particular act, wrong, right, was considered as a crime under international law, that's what you call as a general principles of law recognized by the community of nations, then international law could be used as Sri Lanka law and can punish it. Supreme Court harped on that, and using this, Supreme Court said, yeah, it's possible, it's right to punish Sepala Ekanayake against for what he did using a new law that was passed a month after he had committed the particular act. This is the only response of the Supreme Court when the petition was brought before the Supreme Court. Offences referred to in the bill, that means what? Yeah, offences against the Aircraft Act are all criminal according to the general principles of law recognized by the community of nations. This has been the only instance in the history of Sri Lanka where Supreme Court emphatically recognized the value of international law with regard to a particular case before the Supreme Court. There has never been a similar case since or before that. So this has been the most visible sign of the Sri Lankan Supreme Court accepting the relevance of an international law for the purpose of taking action against the Sri Lankan for doing something which is not considered as a wrong under Sri Lanka law. So, with this decision, now what does await us? This is bound to be interpreted. Supreme Court has a complete power to interpret it, to apply the same principle, or maybe on human rights, environment violations, maybe specific crimes not clearly stated in Sri Lanka law, like let's say cyber crimes, environment. We have an issue at Muthuraja, where it was a Ramsar site and it's been utilized by UDA, at least part of it, for development purposes. That could lead to destruction of part of the Muthuraja Vela marsh. We haven't have passed any enabling legislation on Ramsar Treaty. So, can this decision by the Supreme Court be utilized by the Supreme Court to, expand its scope? What about the human rights? These are questions for the future. And mind you, the word international is visible in some other parts of the Constitution as well. The directive principles of public policy. It clearly says that we have to respect the international law. Article 33, which determines the powers of the President, says this: to do all such acts and things not being inconsistent with the provisions of the Constitution or written law, as by international law, custom or usage is required to or authorized to do so. A President cannot pass a law. The President cannot enact a law. Only the Parliament can do that. But a President can propose something in international law to be taken as part of Sri Lanka law to the Parliament. So that freedom the President has. So it's not that Sri Lanka Constitution ignores international law to a certain extent, right? And take a look at this. The particular Article 13.6 in our Constitution is extremely similar to ex post facto criminal laws mentioned in the Article 11 of the International Bill of Human Rights, Article 15 of the International Convention on the Civil and Political Rights, as well as Article 38, paragraph 1 of Statute of International Court of Justice. So it shows that the fathers and mothers of the Constitution have incorporated certain specifics from international law into our Constitution as well. So can we utilize them in the event where Sri Lanka law is silent with regard to what to do? Take a look at the Express Pearl disaster. Our ship has been destroyed, it's sunk, 4,800 containers have been destroyed. There's massive damage to the environment. It has been one of the world's worst environmental disasters. But sadly, our law is ineffective with regard to taking legal action and claiming compensation for the environmental damage. We do have a Marine Environment Pollution Act, but under that act, the maximum compensation that we can claim is 15 million rupees. Sri Lanka has ratified the MARPOL Convention, but we haven't ratified some other annexes to the convention. So, and we have failed to pass enabling laws locally on MARPOL Convention. Right? It's about Convention on Pollution by Ships. So, because of our failure to enact legislation, our ability to take efficient legal action against this particular ship and related disaster is very, very little. Here, can the Supreme Court utilize general principles of law used by the community of nations? In many other nations, there are effective punishing laws to take action against things like that. So can't we utilize that to take action here using international law, the law used by the community of nations? It's a possibility, but of course it's up to the Supreme Court to determine it. As of now, there's no such news coming up, but the particular decision made by the Supreme Court has huge implications if the court needs to look further through it. Catch you in another lesson.